Good day, Professor Rubel. My name is Scott Douglas Jones, and today I am presenting a critical analysis of Oregon's Measure 11, specifically focused on the intersection of structural inequality and prosecutorial discretion within our juvenile justice system. This presentation will examine how statutory framework designed within an intent of uniform neutrality actually can result in a profoundly unfair real-world outcome. In 1994, the voters of Oregon voted in Measure 11. And when we read the text of Measure 11, it presents itself as a very mechanical and objective statute. However, our core investigation reveals a rather significant divergence between this facially neutral text and a consistent measurable pattern of systemic disparity. The central question we must answer is whether the structural framework of the law itself is inherently flawed, or if these disparate outcomes are actually driven by a systemic bias embedded within institutional implementation. Because we know that Measure 11 reads as a very mechanical, objective statute, yet its outcomes reveal that it is consistently, measurably, has a pattern of systemic disparity. I think to understand the impact of Measure 11, we must first look at the legal machinery itself. When it started in 1995, Measure 11 operated through an automatic transfer, meaning that any juvenile age 15 or older charged with any one of the specific violent offenses was automatically tried in adult criminal court without the initial judicial waiver hearing that they would have got prior. Upon conviction, judges are legally prohibited from exercising sentencing discretion. Statutory minimum sentences are then locked into place. Because of this design, district attorneys act as the true gatekeepers, exercising the unilateral absolute authority to decide whether a case enters into this adult trajectory in the first place. They go straight from the Oregon Department of Justice straight into DOC. So let's talk about this legal machinery, because this process is administered directly through the state's executive legal apparatus. It transitions the youth directly from initial charging by the Department of Justice into adult containment under the Oregon Department of Corrections. By embedding this transfer process directly within state agency workflows, the statutory mechanism functions with automated institutional efficiency. What we end up finding is that any youth charged with a violent offense, 15 or older, they automatically are locked in. The prosecutor gets to choose which ones of these they want, and the only ones that don't get it are the ones that get the plea bargains. That is 92% of the outcomes, and then the judges can't even decide otherwise. It is a mandatory sentence. It is locked into stone. 1, 2, 3. So it's critical to understand that Measure 11 didn't actually eliminate the discretion. It merely reassigned it. Where we used to have the power of allocution, and you would have sentencing judges who were impartial, and they would look at your criminal history. Now, that doesn't exist anymore. Now, these life-altering decisions, they've been placed into private executive chambers controlled entirely by state prosecutors, so that young men as young as 15 years old can be forced to serve adult sentences, life sentences, for juvenile crimes. So this structural design actually shifts the critical transfer decisions into unmonitored space, where geographic policing variations and implicit cultural biases can dictate case trajectories. By shielding these initial charging selections from public or judicial review, what happens is that the system effectively has baked in all of the disparities that are racially motivated and the outcomes that we see, while maintaining this veneer that is supposedly neutral. But if that was true, if it was so neutral, then these facts wouldn't exist. The data demonstrates that these disparities are not random statistical anomalies. Black youth represent only about 1.8% of Oregon's statewide youth population, yet they account for 15.5% of Measure 11 indictments. This is an overrepresentation ratio exceeding 8-to-1. By 2012, Black youth in Oregon were 26 times more likely to face a criminal indictment under Measure 11 compared to their white counterparts. Furthermore, nearly 2/3 of the almost 4,000 youth charged in Measure 11 did not ultimately even result in the Measure 11 conviction. This dramatic divergence strongly indicates systematic overcharging at the prosecutorial stage, highlighting how the threat of mandatory minimums is actually only used as an immense leverage early in the pipeline, just for plea bargains. They're using it just for the leverage. It's a scare tactic to scare young men. And if that wasn't enough, as a result of these mechanics, Oregon now ranks among the highest states in the nation for adult prosecution of juveniles, with roughly 4,000 youth tried in adult courts between 1994, when Measure 11 was first created, and 2012. The fiscal cost of this framework is so substantial, it runs at an annual incarceration cost of approximately $96,000 per individual, despite zero clear causal evidence demonstrating mandatory minimums reduce juvenile crime or enhance public safety literally at all. There is no connection to any recidivism rate decrease at all. From a strictly legal standpoint, the structural rigidity of Measure 11 raises some very serious constitutional concerns. The concentration of unchecked authority in the prosecution without any judicial oversight raises significant due process issues regarding fundamental fairness. Furthermore, while the statute is facially neutral, its starkly disproportionate impact raises equal protection challenges under the 14th Amendment, alongside 8th Amendment concerns regarding mandatory sentencing of juveniles without individualized considerations for developmental differences that we know the Supreme Court has already had many concerns with in cases like Roper, Graham, Miller v. Alabama for adolescents. Mandatory minimums for juveniles strain our evolving standards of decency that our United States Supreme Court just can't go along with. To restore balance, several policy reforms are very vital. First, we must restore judicial waiver authority, returning the power to determine adult prosecution to judges via individualized reviews. Second, we must implement transparent, enforceable criteria governing prosecutorial charging decisions under Measure 11 to end the black box. Finally, we must mandate comprehensive racial and demographic tracking at every decision point in this pipeline. We don't want them taking children and just forcing them through from the cradle to the grave. And this is what we see, especially with Black and brown youth. The limitations of this system are not just some academic abstraction to me. During the 15 years I was within the walls of the prisons of the state of Oregon, serving an unjust sentence for a juvenile Measure 11 crime, for which I was ultimately found actually innocent. In those 15 years, I personally saw firsthand the suffering, the bias, the true disparity of what a 25-to-1 ratio looks like for young men on the streets of Portland, Salem, or even, yes, Roseburg, growing up as a Black or brown teen, knowing that you already have everything leveraged against you, but now the very state of Oregon itself is betting against your future. I also saw firsthand what it looks like when 1 out of 3 of our inmates are Latino and they can't read or write English, when it was my very great privilege to work for 15 years in the ESL and GED programs, helping these underprivileged immigrants gain new skills and even gain their GEDs. I even saw firsthand, working in the prison law library, while winning my own habeas corpus pro se and win my freedom in Jones v. Frankie, the unfairness and inequity that is the systemic neglect and abuse from this very system. While it was my great privilege and pride to help many adults in custody win their cases and their freedom, I also felt the empathetic sting of literal thousands of vicarious losses I experienced with these, my brothers, as they suffered demoralizing defeat after defeat. Each time I would remind them, hey, we're cautiously optimistic and we'll get them next time. But their tears were my tears, and I still to this very day suffer the PTSD of crushing weight of all their bereavement, all their loss and sorrow. For I know these people. I know their families, and I know them like friends and neighbors, and some of them truly as close as my own family. And I know in my heart that they aren't perfect men, but many of them are truly not guilty of what they were charged with, and many more are overcharged or grossly oversentenced. And many of them are just in there for life, and I can never help them. Measure 11 has made many crimes equal to murder, and it has created a vast disparity in our state sentencing, making these young men's futures essentially non-existent. This is why I started years ago in this criminal justice degree, in the hopes that I would someday be able to help rebalance the scales here in Oregon. And next week, I am graduating. And this is but the first of many steps in that very worthy pursuit. Thank you.